Okay. There we go. And who else do we have before the court? So who is, there you go. And can you please,
Yes, Your Honor. My name is Ed. I'm with an organization called Americans Against Foreclosures, and we're not interested party directly, but we'd like to be present in the hearing.
okay, very well. Ms. Sutton, you may proceed.
Your Honor, before the court is Nation Star's motion to declare plaintiff Harriet Nicholson a vexatious litigant pursuant to Chapter 11 of the Texas Civil Practice and Remedies Code. In this present action, plaintiff has continued to attempt to relitigate her claims relating to the foreclosure of real property located at 2951 Santa Sabina Drive in Grand Prairie. This most recent lawsuit seeks to void and vacate an order of judgment, both of which were entered in the 48th District Court of Tarrant County, Texas. Specifically, plaintiff seeks a declaratory relief to render void a May 21st, 2021 order of vacating an order denying motion to set a status conference, and also a July 13th, 2021 final judgment. This was all argued before, Your Honor, at the November 22nd hearing on plaintiff's MSJ. So while this may be plaintiff's first action in Dallas County, she has an extensive filing history in Tarrant County and with the appellate courts of Texas, with all the lawsuits actually involving the property I mentioned that I'll refer to as a property and its foreclosures. Plaintiff's claims with the foreclosure process and the alleged acts of the lender, the loan servicers, and substitute trustees have been litigated repeatedly by not only the Tarrant County District Courts, but also the Second Court of Appeals and the Texas Supreme Court. In fact, this present lawsuit that was filed in Dallas County is just simply a continuation of the MO plaintiff filing frivolous pro se lawsuits regarding the property. In this case, and per our motion, because each of the elements of Chapter 11 of Civil Practice and Remedies Code are met, Nation Star is asking that the court declare plaintiff Harriet Nicholson as a vexatious litigant, require security to be posted, and enter a pre-filing order prohibiting Ms. Nicholson from new filings without permission as set forth in sections 11.101 to 102. Also, Your Honor, this motion—
Hold on for just a second, just so that I'm following your petition. Under CPRC 11.054, which section is movement proceeding under?
Actually, Your Honor, we are proceeding, and let me, under the, you're talking about the legal standard about the numerosity.
Well, you had to slow down a little bit because we're trying to take a record.
Yeah, the numerosity and relitigation, Your Honor. So as to both.
Okay. You may proceed.
In the actual motion, Your Honor, there is 1, 2, 3, 4, 5, 6, 7, 13 pieces of evidence that we have set forth in support of this motion, and we would request that the court take judicial notice, as these are pleadings, orders, and dockets that are all of record in other proceedings.
Okay. Anything else?
That is it for our motion, Your Honor, as far as the judicial notice request.
Well,
yeah,
the court takes judicial notice of what's in the court's file.
Thanks, Your Honor. As far as the legal standard for the numerosity and or relitigation method of section 11.054, 11.0541 provides that a trial court may find that a plaintiff is a vexatious litigant if the defendant demonstrates that there is no reasonable probability the plaintiff will prevail in the litigation against the defendant. And then in the 7-year period prior, immediately preceding the date that this motion was filed, plaintiff commenced, prosecuted, or maintained at least 5 litigations as a pro se litigant that have been finally determined adversely to plaintiff, permitted to remain pending, or determined by a court to be groundless. 11.0542, Your Honor, provides that a trial court may find a plaintiff a vexatious litigant if, after a litigation has been finally determined against the plaintiff then repeatedly relitigates or attempts to relitigate pro se the cause of action, claim, controversy, or any of the issues.
Sorry, counsel, say that one more time.
If the plaintiff repeatedly relitigates or attempts to relitigate in a pro se manner the cause of action, claim, controversy, or any of the issues of fact or law determined or concluded by the final determination against the same defendant as to whom the litigation was finally determined. In this case, both the numerosity method of 11.0541 and the relitigation method of 11.0542 are established to support NationStar's motion to declare plaintiff Harriet Nicholson as a vexatious litigant. Now, in regard to the numerosity method under section 11.0541, as I stated, there's numerous actions that establish that plaintiff in the previous 7-year period has commenced, prosecuted, or maintained at least 5 litigations, including appeals, as a pro se litigant that have been finally determined adversely to her or determined by a trial or appellate court to be frivolous or groundless. These filings include the following, and you'll have to bear with me, Your Honor, there's quite a few. Cause number 342-2692-12. Cause number 048276347-15. Case number 2-18-00035-CV. And this is an appeal from case number 342-262692. The fourth example is case number 02-19-00022-CV. The fifth example is case number 02-19-00085-CV. And this is an appeal from case number 048.
I'm sorry, if you are not speaking, if you wouldn't mind, please mute your microphone. Thank you.
This is an appeal, Your Honor, the fifth example from cause number 048-304-598-18. The sixth example is case number 02-19-00103-CV.
I'm sorry, repeat that one again, counsel.
Sorry, 02-19-00103-CV. And this is an appeal from cause number 048-305-585-19. The seventh example is case number 19-0357. And this is on petition for review from the Second Court of Appeals in case number 02-18-00035-CV. The eighth example is case number 02-19-00163-CV. And this was actually petitioned from cause number 342-262-692-12. The ninth example, Your Honor, is case number 20-0151. And this was petitioned from cause numbers 02-19-00085-CV and 02-19-00103-CV in the Second Court of Appeals. In the 10th example, Your Honor, and bear with me, I'm almost done with them. In case number 02-20-00180-CV. This matter was on appeal from cause number 048-286-132-0 The 11th example, Your Honor, is case number 02-21-00068-CV. This was petitioned from cause number 048-27-6347-15. And the 13th example, Your Honor, is case number 21-0422, the Supreme Court of Texas. And this is petitioned from case number 02-20-00180-CV in the Second Court of Appeals. These cases have all been denied or ruled adversely to plaintiff. So the above referenced examples that I gave you, the 13, relate to the property in which plaintiff Harriet Nicholson had an interest, established plaintiff's repeated attempts to relitigate final determinations against her. Despite those final determinations, though, Your Honor, plaintiff has abused our judicial process. Including this present suit, also established the numerosity method pursuant to section 11.0541, sufficient to declare plaintiff a vexatious litigant, requires security and entry of a pre-filing order. Your Honor, plaintiff is exactly the type of abusive litigant this legislator thought to thwart with Chapter 11 of the Civil Practice and Remedies Code. She's continued to abuse the judicial system with multiple frivolous lawsuits within the past 7 years, as well as attempted to repeatedly litigate finally determined issues and claims against the same defendants and involving the same property. Now, the relitigation method, Your Honor, pursuant to section 11.0542 is also established. The above referenced suits, the 13 examples that I named off the cause numbers, relate to the property and establish plaintiff's repeated attempts to relitigate final determinations against not only my client NationStar, but the current and prior mortgagees, prior mortgage servicers, and also their counsel. Despite those final determinations against them, plaintiff repeatedly relitigates or attempts to relitigate pro se the cause of action, claim, controversy, or any of the issues of fact or law determined or concluded by the final determination. Such attempted relitigation, including this present suit, Your Honor, in front of the court, established the relitigation method of Texas Civil Practice and Remedies Code 11.0542, sufficient to also declare plaintiff Harriet Nicholson a vexatious litigant, requires security, and also the entry of a pre-filing order. Now, in this matter, plaintiff cannot and will not prevail. It's established that plaintiff, from all the examples I provided, Your Honor, is a vexatious litigant and serial filer in Texas state courts. She's filed numerous frivolous and repetitive lawsuits concerning the same property, which is actually the subject of her most current suit and pleading. Now, relative to the property at issue and the current filed litigation before the court, plaintiff originally filed her first suit in 2012 under cause number 342-262-692-12 in the 342nd Judicial District Court, ultimately against 11 separate defendants. Now, this case was finally adjudicated and dismissed. Since this initial suit was filed in 2012, plaintiff has filed at least 18 additional lawsuits, Your Honor. This includes appeals and petitions for review with the same bogus inherent allegations of fraud, negligence, conspiracy, requests for a declaratory judgment, and violations of section 12.002 of the Texas Civil Practice and Remedies Code. All of these causes of action relate to the foreclosure and or eviction of the property. Now, despite 13 district courts, Second Court of Appeals, and the Supreme Court cases, which have issued final dispositive judgments rejecting plaintiff's claims, plaintiff filed this current lawsuit in Dallas County, trying to litigate her numerous claims, all of which have all been rejected at least 13 times in final judgments. Now, in this particular suit, Your Honor, plaintiff has no reasonable probability to prevail because she has no standing to bring her claims in Dallas County. Jurisdiction presently, at this time, lies with the Second Court of Appeals in Texas, and the trial court had jurisdiction when the subject order and judgment that plaintiff is seeking to void by this lawsuit were actually entered. Specifically, Your Honor, and I know that plaintiff is going to address this because this was in her response, but as I mentioned before, these items were addressed in the 1122 hearing on plaintiff's MSJ. So in this matter, by plaintiff's amended petition, she seeks declaratory relief to render void an order and a judgment by the 48th Judicial Court.
I'm sorry, you said the 48th?
Yes, I'm sorry, 48th Judicial Court. Plaintiff contends that she filed a notice of appeal in the Second Court of Appeals on March 17, 2021, and that therefore the Tarrant County Court in the 48th District Court did not have jurisdiction to enter its May 21st, 2021 order vacating order denying motion to set status conference or its July 13, 2021 final judgment. However, as it's clear from the Second Court of Appeals abatement order dated April 19, 2021, the appeal was actually abated for 30 days to allow the trial court to clarify whether it intended its May 17th order granting defendants no evidence motion for summary judgment to be a final judgment disposing of all claims and parties, or whether it intended actually to be a non-appealable interlocutory order. So subsequently, on May 20th, 2021, the 48th District Court requested an extension of the abatement order. And in this matter, the appellate court granted the request and extended the abatement by 60 days until July 19, 2021. This then enabled Judge Evans to enter the July 13, 2021 final judgment while the case remained abated in the Second Court of Appeals. That is the judgment that actually is before the court that plaintiff is seeking to void by arguing that the court did not have jurisdiction. And in fact, at the November 22nd MSJ hearing, the judge agreed that the Second Court abatement gave the trial court jurisdiction to clarify its orders, Your Honor. So Nation Star respectfully requests that pursuant to 11.054 subsections 1 and 2, that the court declare plaintiff Harriet Nicholson a vexatious litigant, require security, and enter a pre-filing order prohibiting Ms. Nicholson from filing pro se any new litigation without the permission of the local administrative judge, Your Honor.
Okay, thank you. Ms. Nicholson, you may respond. Ms. Nicholson? Ms. Nicholson, are you there?
Your Honor, it looks like the number she called in from is still on there, but I don't know if something happened.
Yeah, I see the same. If you're on mute, Ms. Nicholson, well, it doesn't look like you're on mute. I'm going to wait one more second to see if she'd like to respond. Ms. Nicholson, would you like to respond? And the court notes that she does still appear to be present by phone. She does not have
I'm here. I'm having phone difficulties. Can you hear me?
Would you like to respond?
Hello?
Would you like to respond?
Yes. I'm here.
I understand that you're there. Would you like to respond, Ms. Nicholson?
Yes, I would like to respond.
Okay, you may.
Yes, I would like to respond. Is anyone there?
We are here. Would you need to respond
Yes.
right now?
Yes, I do want to respond. Can you hear me?
We can hear you. We can hear you.
Okay, Your Honor. In response to the vexatious litigant motion filed by Nation Star, Your Honor, in response to Nation Star's okay. Your Honor, in response to Nation Star's motion for vexation, the Chapter 11 statute.
I'm sorry, I can't hear you.
Ms. Nicholson, you're not audible. I'm going to give you one more minute to try to get back on. Otherwise, I'm gonna finalize this matter and move on to my next hearing. Do you have any response, Ms. Nicholson? Okay, the court will take under advisement the motion. Let me look at the evidence. I do note that Ms. Nicholson has a response on file, which I will also review, and I will enter an order accordingly. Thank you. You all are excused.
Thank you.
Your Honor,
Do we have a 12 o'clock shredout? Let me.
Your Honor, apparently there